If you are going through bankruptcy and receive notice of an adversary proceeding, it can feel confusing and intimidating. But the simplest way to understand it is this. An adversary proceeding is basically a lawsuit inside the bankruptcy case. It is separate from the normal bankruptcy process, and it can have a major impact on whether certain debts are discharged. It can also determine whether creditors can continue pursuing payment and how your case moves forward. In a regular bankruptcy case, the court reviews your financial situation and determines what relief may be available under the bankruptcy code. But an adversary proceeding is more like traditional litigation with a complaint, an answer, and a judge resolving the dispute. These disputes often involve disagreements between a debtor, a creditor, a trustee, or another interested party. Not every bankruptcy case has an adversary proceeding. Many cases move through without one. Adversary proceedings happen when a dispute cannot be resolved through the standard bankruptcy process and needs a judge's decision. Common reasons include a creditor objecting to discharge or arguing that a specific debt should not be discharged. Other reasons include allegations of fraud or misrepresentation and disputes over asset transfers before bankruptcy. There can also be questions about whether money or property should be returned to the bankruptcy estate or disputes about liens. One key point is that an adversary complaint starts a separate case inside the bankruptcy with its own procedures and timeline. A common type is an objection to discharge, where a creditor or trustee alleges misconduct or missing information. Another common type is a determination of dischargeability, where the court decides if a specific debt can be wiped out. A third example is a fraudulent transfer action, where creditors claim assets were shifted to avoid paying debts. Adversary proceedings are not just paperwork disputes. They can affect whether debts go away, whether assets are recovered, or whether your case gets more complicated. The basic process begins when someone files an adversary complaint in the bankruptcy court. The other party must respond within a strict deadline, which is often around 30 days depending on the rules. After the answer, the case may move into discovery, where parties exchange documents and information under set rules. Many adversary cases will settle through negotiation or mediation before reaching trial, which can save time and cost. If the case does not settle, it proceeds to trial, where the bankruptcy judge hears evidence and issues a decision. One of the biggest mistakes people make is assuming this is just another notice from the court and ignoring it. If you are served with an adversary complaint, you need to pay attention to the deadline to respond and consult an attorney promptly. Responding on time and participating in discovery protects your rights and preserves defenses that could defeat the complaint. Practical examples include a creditor claiming you charged luxury purchases on the eve of filing or alleging false statements on your forms. Another example is a trustee seeking to recover money a relative received shortly before you filed bankruptcy. Facing an adversary proceeding does not always mean you will lose your discharge, but it does mean you should take the process seriously. If a debt is found non-dischargeable, you may still negotiate payment terms or challenge the legal basis for the claim. Because adversary proceedings can change outcomes and timelines, it is important to work with counsel experienced in bankruptcy litigation. If you received a notice of an adversary proceeding, contact the Phillips Law Offices in Greenbelt to discuss your options and next steps. Taking prompt, informed action can protect your discharge and help bring your bankruptcy case to a successful resolution.